Are you a business owner? Then you already know that taxes and expenses can easily take 20 to 50% of your revenue, if not more. This one fact alone keeps your business from growing and taking home large profits. What if there were tens or even hundreds of thousands of dollars of profit in your business that you weren't even aware of, and you're missing out on this profit every month? Most businesses in the US have this profit but have no clue that it's sitting right in front of them. Today, you will see a completely legal way to access this profit without a change in your cash flow or affecting your current business in any major way. Here's how it works. When you generate income through your company, that money or profit eventually comes over to your personal bank account or estate. This is what we call your personal estate. Those funds came to your account, but at a huge cost: taxes. Then, with the funds from your bank account, you purchase assets and things such as a house, a car, a boat, etc. All of these assets cost money, and you have to pay expenses on top of these assets. Take, for example, your home. The ancillary costs are your mortgage payment, electric bill, water bill, gas bill, taxes, insurance, the list goes on. And that's just for one personal asset. The problem with this normal structure of taking profit is that in order to pay the bills for these assets, you have to pay those expenses using funds from a bank account, where you were taxed in order to receive the money. You see, there was a penalty to pay to receive that profit personally. That penalty is personal taxation. You have to use your personal estate to pay for these costs, but you have to pay a huge price in tax in order to receive it. So the actual bills you pay cost you more than the bill itself. And why do you have to pay these bills personally? Because you personally own these assets. You're the owner. If you're the owner, then you have to maintain them. So you need money to do that. And where will you get that money? Well, from a bank account that you also own. What's wrong with that? Well, you have to be taxed on that money in order to pay those bills. That's the problem. But what if there was a better way? What if you could sell your assets over to a specialized trust so that you no longer personally own them? Now, don't worry, you still control everything as the trustee in this unique trust. You still have 100% control of the asset. The only difference is you no longer own it. The trust does. Consider this concept. In the world of business, there is a rule called the Rockefeller Rule, which states that the secret to wealth and profit is to own nothing but control everything. You see, John Rockefeller was one of the richest men in the world, and he said if you want wealth, then you can't be the owner of it. You have to let it go. Rockefeller sold everything he had into multiple trusts, just like the one we are talking about. Instead of owning the assets, which only gives you limited control, he controls the assets with ultimate control because he doesn't own it anymore. This means he can never lose the asset in a lawsuit or even have to worry about personal liability anymore. The courts can't take the asset from him. Why? Because he doesn't own it. And let's take this concept one step further. If you no longer personally own the assets, then you no longer have to personally pay asset-related expenses either. Are you starting to see the incredible power of a specialized trust? Let's review. The specialized trust would own your assets, and the trust is therefore responsible for paying all related expenses. And don't worry, you can be the trustee of the trust, so you always maintain control of all assets held within the trust. What you have to understand is that, unlike the personal estate structure you currently use, the trust estate can bring in the same money from your business, but without the tax burden that you're paying now. The trust gets huge tax avoidance that you can't get personally. That's because there are unique tax codes that allow this specialized trust to avoid many of the taxes that you have to currently pay. This allows the difference to remain in the trust, and you avoid having to pay many of those large tax liabilities. Would you like to know how this can work for you? This specialized trust not only helps avoid taxes, but it can also build a huge legacy for your family at the same time. And if you're thinking trusts sound complicated and expensive, you owe it to yourself and your family to let us show you exactly how we can help set up a trust that may help save you an enormous amount of money. Ask yourself, am I paying $10,000, $25,000, $50,000, or even $100,000 a year in taxes? Why do that if you have options? It's time to know your options. We can help you avoid these high tax bills with a stroke of a pen. What do you have to lose?
All right. Well, thanks everyone for joining the call tonight. This is Scott McGrath, and I'm with Nexxess International, and I'm going to show you a quick PowerPoint, and we're going to do a quick presentation about our trust program, and then we are going to do Q&A, question and answer. If you do have a question, please write it down and we will get to you very soon. So thanks for joining. I'm going to take you through a quick PowerPoint. We're going to do some whiteboard presentations and hopefully do some illustrations, and we will get to your Q&A very soon. So let's talk about who we are as a company, Nexxess International. We are a trust management company. We are a business planning company. We set up business structures for people around the country in the United States here. And we are in the Dallas-Fort Worth area. We're in a small little town called Bedford, right, sandwiched right between Dallas and Fort Worth, right by the DFW airport. So if you fly into Dallas-Fort Worth, we'll be happy to pick you up and see if we can help you, bring you to our office. We're only 5 minutes from the airport. So that's just a little bit about us. And before we get started, let me tell you real quick, everything I say is informational purposes only. It's not for legal or financial advice or tax advice. So so let's talk about me. I am not a CPA. I'm not an attorney, but I am a financial planner by trade, and I do financial planning. I help people make decisions with their financial situation in various formats. And if we do need an attorney or we do need a CPA, we do bring those people on to help you in those various fields of expertise. So we have 4 attorneys that work in our office, that work with our office, and we have several CPAs, several enrolled agents, and we have we just expanded our office, by the way. We're in the largest office on the 5th floor, the top floor of our building here in Bedford. So we have about 3 times the space that we had about a week ago. So we are growing. So, all right, let me tell you a little bit about what we do. We help people with trust, case law, tax code, and contract law, because the product we offer has a lot to do with helping people in their business, if they're a business owner, and helping people increase their cash flow, protect their assets, and multiple different things like that. We always use trust, case law, tax code, and contract law with everything we do. And so we use highly unique trust products to provide anonymity, asset protection, and tax strategies. So I like to share a quote with everyone. Billings Hand, he's a judge, Court of Appeals. Anyone can arrange their affairs so their taxes are as low as possible. They're not bound to choose the pattern which best pays the Treasury. You can look up this quote. I'm not going to read it all, but just remember, you do not have to use the pattern which best pays the Treasury. This came from a judge. So if you look on the screen here, there's a bunch of companies here, and these companies pay 0 federal income tax. And why do they do that? Well, they use the tax code to their advantage. And it's estimated that one half of all Fortune 500 companies around the country do not pay federal income tax. And so they don't have to if they use the code to their advantage, and that's what most of them do. And if you are paying taxes, maybe you're a business owner and you have a large tax bill, you may want to consider A, keeping your options open, or B, finding a new tax preparer, finding a new financial planner or something. You do not have to pay all that money to the government, and you should not do it. You should be diverting that money into either a retirement account for yourself, or you should be diverting that money into a trust. So please don't give your money away to the government if you don't have to. Your grandchildren will thank you, okay? All right. We do not do tax evasion. What we do is what's called tax avoidance. So the IRS says there are 4 things that are legal in our country: tax avoidance, tax reduction, tax minimization, and tax alleviation. Those are the 4 things that are legal. And what's not legal is to evade taxes, which are displayed here on the screen. Intentionally doing something, deceiving and concealing, those kind of things are wrong and go to jail for that. We don't do that. What do? We do financial planning. We help people with more than just trust. We help them with mortgages. We help them with retirement accounts. We have registered reps at Nexxess. We have over 50 insurance agents with our insurance agency, Nexxess Financial. So we also have recently started a brokerage firm where we are buying and selling companies now. That's called corporatesales.com. So we have multiple different ways to help our customers, not just the trust, not just the insurance, but many other things. So let's talk about the key features of our specialized trust. You may maintain all of your relationships with your lawyer or CPA. You don't have to go and fire all of your friends and family members that help you, but you might want to. If they are costing you a lot of money, you may want to reconsider hiring them. At the end of the day, the proof's in the pudding. You should look at your tax bill and decide, what are my options? What if the tax bill you have is not your only option? What if there are other options? And we recommend you to look at those options. So that's what we do. We help you see your options. What are those options? Those options are ultimate asset invisibility. That's called privacy. We call that privacy. Ultimate asset protection. That means 0 lawsuits. So far to date, I've been doing financial planning for over 20 years. I've been doing trust setup for 7 years now, and I have 0 clients that have received a lawsuit on anything in their trust. So it could change, but so far, no lawsuits. There's a reason for that, because it's very difficult to sue a spendthrift trust, almost impossible. So you definitely want to look at that if you are either tired of lawsuits or you don't want them. Ultimate asset control, what does that mean? That means you can sell your assets. Okay, and no one can come and take them from you. So think about this: if a judge has the power to issue a turnover order on your assets, in other words, you go to court, you owe a credit card or you owe someone money, you go to court, the judge files a judgment, the judge orders a judgment against you. Think about that. What's the next step from the judgment? Is the turnover order. They're going to turn over. He's going to order you to turn over your assets to pay for the judgment, right? With our trust, no court in America is able to issue a turnover order against the things in our trust. It's not allowed. There are Supreme Court rulings that don't allow that. So we call that ultimate asset control, having the ability for no one to be able to come in and take something from your trust. Now, if you have a living trust, if you own something in what we call your personal estate, they can come all day long and pull everything out of that living trust, pull everything out of your personal estate to pay any bills that you have. So you might want to consider a different structure if you're living out of a personal estate, or all your assets are in your personal estate, or if maybe you have a living trust. Your assets are not protected, so any judge can issue a turnover order. You can lose everything in that trust. So the last two are even more valuable: ultimate tax benefits. Now, that's the number one reason people come to us and walk through our doors, because they are tired of bleeding out money to the government. So we call that ultimate tax benefits. And the last one is true peace of mind. So what is the key problem with most trusts? So many people who come to visit us, they already have trust. They have a simple trust. They have a living trust. They have a revocable trust, whatever. We have to explain to them that trust uses a different tax code. Okay, it still uses the same tax, the same overall tax code, but it uses inside of our tax code is something called the simple tax code, and we use one called the complex tax code. So the tax code is about 14,000 pages long. If you printed it all out and stacked it all up, it'd go from the floor to the ceiling. And you probably have never read it all. Most CPAs have never read it all. But what you're going to find is in the tax code, there are basically 2 paths that a trust can go. It can be either a simple trust or it can be a complex trust. So just for fun, I'm going to share my whiteboard screen. I'm going to show you how that works. Okay, so let's pretend you make money. You have money and you have a trust also. Okay, I'm going to draw the 2 trusts here. I'm going to draw a simple trust, and I'm going to put here a complex trust. So 2 different trusts, they both use different tax codes, the same code, but different sections of the code. So you're making money, the money comes into a simple trust. Now this is a good example. This is a living trust. So think about this for a minute. If you open a phone book, you call a law firm or any attorney, it doesn't matter, pick your poison, call them. They are going to sell you a living trust without asking you what type of trust do you want. They're going to just sell you a living trust. Okay. And so the problem with living trust or trust that use the simple tax code is when the money comes in, it has to be distributed down to a beneficiary. Okay. Or you can pay the tax immediately if you want to through the trust, no problem. Okay. You're going to use a 1041. The trust will have its own tax EIN number, and it will have its own tax return. So you have two options basically. You pay the tax or you can distribute that money. Now this is income, by the way. So income is earned from what? An asset. So maybe you have money in some kind of maybe a rental property, or maybe you have money in a Schwab account. Whatever you have in that trust, it's going to use the simple tax code. So when that income comes in, it has to be distributed and it goes on the beneficiary's tax return. Okay. Now, the problem with that trust is it requires you to distribute income. Now, let me show you the type of trust that you want to have. When you earn money, you want the trust coming into a complex trust, okay? But in a complex trust, okay, there is no requirement at all to distribute the income. No requirement. You do not have to distribute the income as long as the language is correct in the complex trust. What that means is you can keep the money in what's called corpus. Corpus is the body of the trust. It's the part of the trust where all the money is and the assets, the rental properties, the gold, the guns, the jewelry, the cars, the boats, you know, all of the homes that the trust owns, the money, bank accounts. If it's an asset set aside to make money for the trust, that's called corpus. All right, so the money comes in, but there's no requirement to distribute. In fact, you do not have to distribute that income. What I've learned is that if you distribute that income, you will be having to use the simple tax code for that tax year. If you distribute down here to this beneficiary in the complex trust, you will be using the simple tax code. Now, what I've learned recently, okay, and had explained a little bit more in depth, is you can distribute, and we all know you have been able to distribute from complex trust, okay? But you don't want to distribute this, okay? You want to distribute from the corpus, okay? You don't want to distribute from income. If you distribute from income, you use the simple code, and it can cause issues and problems. What you want to do is distribute from the corpus, okay? You want to if you're going to distribute, you distribute from corpus, and it is money or assets that have already been declared extraordinary and put into corpus. So that's a whole nother conversation. We can do a training on that later. But understand, both trusts, you can distribute from both trusts. But how you distribute determines what the tax looks like. And so what I'm going to share with you tonight is, if you want all those 5 living benefits, you need a trust, okay, that allows you, hold on a second, let me change my color. I'm going to make it red. Okay, you need a trust that allows you to use the complex code and allocate everything. Okay, allocate everything to the corpus of the trust. You need to be able to allocate everything to the corpus of the trust. That's important, because you don't want to have to distribute if you don't want to distribute. Remember that. And so if you have the wrong trust, you're going to end up having to distribute that income. All right, so let's go back to the PowerPoint. And so there I was explaining to you the key problem with most trusts. Okay, they have to distribute, and that's a problem. Okay, so we want to have the complex tax codes apply to our tax return for the year, so we can take advantage of no capital gains and no tax liabilities, current tax liabilities, lawsuits, liens and levies, divorces. We don't want to have a bunch of problems with our assets. And so let's talk for a minute about what is a trust. So some people, we keep talking about trust. Some people might not know what a trust is. Well, a trust is simply when you take money or property or assets and you put it over here for the benefit of someone over here. Okay, again, you take money or property or assets, you put it over here for the benefit of someone over here. That's what a trust is. So Black's Law Dictionary says it's an equitable or beneficial right or title to land or other property. It's held by one party, but it's for the benefit of another party. That's what a trust is. And so trustees hold the legal and equitable title to the property for the benefit of the beneficiaries. All right. So that's what it is a trust doesn't own anything ever. It never owns anything. It only holds the asset. It doesn't own it. It just holds it. It protects it. It keeps it, anyone from coming and taking anything in the trust if you have the right trust. If you have a living trust or grantor trust or the wrong type of trust, then yes, the judges can come in and take everything. But if you have the right trust, they can't do that. And I can show you later how that works, but let's talk real quick about who is a settlor. What is a settlor? There are three parties in a trust. Number one, a settlor. Number two, a trustee. And number three, a beneficiary. So every trust has three main people in the trust. The settlor is sometimes called the creator, the grantor, or the trustor. It's the person who creates the trust for the benefit of the beneficiaries. So to establish a trust and realize the protection afforded, the trust should be established through an initial funding by the settlor. In other words, the settlor puts the first asset in the trust. That's why they're called the settlor, because they settle the first asset in the trust. Okay. After the trust is established, the trustee may convey additional assets if they want to, tangible or intangible, to the trust for the benefit of the beneficiaries. Okay. So that's what the settlor is. All right. So the next person in the trust is called the trustee. The trustee is the person or institution or company or whomever who manages the assets. So I'm going to show you tonight that you definitely want to be the trustee. You don't want someone telling you you can't be the trustee. All right. So you definitely want to be the trustee. Why? Because you want to be able to manage your own asset in the trust that you sold to the trust. So let me show you how that works. There may be one or more trustees. If a trustee is unable or unwilling to serve, then the successor trustee. So what happens when this trustee dies? The beneficiary or whomever the trustee decided can be a successor to their trustee position. So the trust doesn't die or end. It's still going. You just have a successor trustee, someone who steps in and does start managing everything. Okay, and that's what happens. So the third position in the trust is the beneficiary. So what is a beneficiary? It's a person or entity that benefits from the trust estate. The rights of beneficiaries depend on the terms and conditions of the trust. Beneficiaries have no equitable title, only a beneficial interest in the property or assets held in the trust. Now, this is I'm speaking of the trust that we set up. Okay, in some trusts, the beneficiaries do have equitable title, but not our trust. Okay, we don't want equitable title. We don't want the courts to be able to come in and take the assets out of the trust. Remember this: if you have equitable title, you could lose the asset. Okay, the courts can come in and take it from you because you not only hold the equity, own the equity, you also hold title. If you hold both together, someone can take the asset from you, and you don't want that. So the trust holds title, but doesn't hold equitable title to the assets. And that's real important. Beneficiaries have no right of management of the trust, nor have any right to access to business records or knowledge of the trust, business, or actions. Why? Because that's what it says in the trust document. Whoever set it up, that's what they set it up so that it's like that. Our trust is a spendthrift trust, which means the beneficiaries do not have rights or access to anything unless they're given that from the trustee. And that's why our trust has all the powers that it has. Okay, so let's see here. Beneficiary, that's the last person. So remember, there are three people. There is the settlor, there is the trustee, and the beneficiary. All right, so let's talk real quick about the trust estate. So everyone has an estate. If you're just an individual and you die, guess what? You still own things. You might own a car or a house or something. You might have some money in your pocket. But whatever you own when you die is part of your estate, a personal estate. Well, the trust is the same way. The trust has its own estate. Okay, the property or assets that are transferred into a trust become the trust corpus, which then become the trust estate. The trustee of a trust is the only person or entity that can affect the transfer of those assets or money or property. A trust estate consists of all the property, tangible or intangible. Remember, assets can be intangible. Okay, copyrights, patents, trademarks, secret processes. There can be a lot of things called intellectual property. You can't put it in your hand, but it does exist. It's intangible. It might be software of a company. Can't really put software in your hand, really. So assets, cash, rights, obligations, they're all transferred into the trust. And those things become the trust estate. So you put all these things in the trust. Now the trust owns all of, or doesn't own all these things. It holds all of these things. Okay. And now what can it do? It can now lease all those things to businesses or lease that stuff to people or whomever. And so there are a lot of cool things that can happen once the trust estate owns it. All right. Let's talk about the history of the trust. Okay, this is not the history of Nexxess, this is the history about the trust. Our trust goes back way before the U.S. Constitution was established, back to the 1500s. King Henry VIII set up the very first spendthrift trust back in the 1500s. Comes from what we call laws of antiquity, European common law. So European common law, which means the common law right to contract, meaning you have the right to contract with anyone. You can make a contract or an agreement with someone, and you can mow their yard for $1 million, I like to say. There's no one that can come in between your contract. If you say, hey, I want to mow your yard for $1 million, there's no one can stop that, okay? Not the city, not the state. You have the right to form a contract with someone. And that's what a trust is, just so you know. The actual U.S. Constitution itself was created in the form of a trust. So it has beneficiaries to it. It has an agreement, trust agreement. It's a trust in and of itself. No state or federal regulation, authority, or judge can be above the U.S. Constitution. Therefore, you cannot penetrate a true spendthrift trust. This has stood the test of time for decades. Zero case law of this trust not protecting assets. This is the financial instrument of the super wealthy. It gives them peace of mind. So why not take advantage of it for yourself? Speaking of the super wealthy, we like to talk about John Rockefeller. John Rockefeller is notably the most influential and richest man ever to have lived. He created a trust called the Standard Oil Trust. He used the trust to basically monopolize many types of industries, and the government didn't like it. And he got so big and grew so fast that the government actually came in and shut him down in many cases. And they were able to do that. But he outsmarted them, because all he did was take his one trust and then open up a bunch of other trusts and basically took all of his industries and things that he did and made it multiple trusts. And then he got even more wealthy. So the Rockefeller family is still some of the wealthiest people in the world. So you can do what the Rockefellers did. There's nothing wrong with doing what they did. And we can show you how to do that and how to parlay your money. Okay, think about this for a minute. If you're not giving 30% of your income to the government and you're able to do something with that 30% of that income, think of how much your business could grow if you had a marketing budget the size of your tax bill. Think about that for a minute. That's what these business people do. They use that extra money that all their competitors are paying to the government. They use that for smart and savvy purposes. And they have the right to do that because they got their structure right. Get your structure right, and you can do what you want to do. Like I like to say, the roots create the fruits. If you have a tree, the roots create the structure. Tells you a lot about what you have on the surface and can help you with the planning of your business and your money and everything. So let's talk for a second about Article 1 of the Constitution. So remember, we talked about the contract, the right to contract. The Article 1 of the Constitution, Section 10, Clause 1 says, no state can pass a law that impairs the obligation of contracts. So some people like to say, well, your trust is great, Scott, but tomorrow or in a couple of years, they're going to change the law and you're not going to have your trust anymore. Well, that could never happen because number one, they're not ever going to get rid of Article 1 because every business in America uses Article 1 all day, every day, because every business out there, insurance companies, the people that mow your yard, everything is based in contracts. Okay, they make you sign something, and without that contract, two people can't work together. There would be no economy. There would be no commerce. So they're never going to get rid of Article 1. So keep that in mind. Courts can determine the enforceability of contracts, but only on public policy grounds. All right, here we go. And the next slide is what John Rockefeller used to say. He always said, own nothing but control everything. So what do? We teach people not only what they did, but what they said. John Rockefeller said, own nothing but control everything. So what he taught was that if you want to be wealthy, you cannot be the owner. Okay, you can't be the owner of it. So John Rockefeller was very clear. He said, get rid of the ownership and now you can have control. Okay, so I'm going to share my screen. I'm going to go over something. I'm going to go over another concept. I think it's important for you to see. Okay, I'm going to draw out, remember the personal estate. Remember if someone died and anything they owned, it would fall into their personal estate, and that probably ends up in a courtroom when they die, everything goes into the court and goes to probate and those types of things. The judge decides where all their assets go, basically. Okay, I'm going to draw two buckets, though. I'm going to draw a trust bucket, and then I'm going to draw the personal estate bucket. I'm just going to put the word you here. You're the client, okay, and then here's the trust. So what I like to explain, and by the way, I like to put business owner here too. Business owner. Because when the number one person I help, or the number one person I'm looking for, is a business owner. So if you ask me who I'm looking for, I'm really, really focused on business owners. Why? Because business owners get to control their structure. Think about this. If you work at Walmart and you punch a clock, you don't get to control your structure. They tell you you're going to be a W-2 employee. They tell you when to show up. They tell you when to jump, how high to jump, and they control everything about what you do. And that's called W-2 income. But W-2 income is also called guaranteed income. Okay, so if it's guaranteed, you can't control the income. You don't get to control. It's guaranteed income and it's W-2. The employer controls it, and you don't get to make any changes or anything. So I like to target people who can control their structure. I like to talk to people who are business owners, because I'm going to draw out 7 different things. So I want you to see this, because I want you to understand the power of the trust program. Okay. So I'm going to draw this out. So, and first I'm going to put ownership. Okay. So ownership, I'm going to put the word management. Okay. Ownership, management, control. I'm going to put the word access. I'm going to put liability. I'm going to put taxes. And I'm going to put lawsuits. Okay. Now, remember we talked about the personal estate. Remember, everything you own is in your personal estate. Now, there are 7 things that matter to the people that matter to me. I look for business owners. I care about business owners. I'm trying to talk to business owners. The reason I want to talk to business owners is because I want to show them that there are 7 things that matter to you. Okay. Ownership, management, control, access, liability, taxes, and lawsuits. Now, if you are the owner, and I'm going to circle the owner real quick. I want to show you this. If you're the owner, okay, ownership comes with not privileges, it comes with disadvantages. Number one, if you're the owner, I can sue you because you're the owner. That's the first problem. Remember, John Rockefeller said, own nothing. Well, it's funny because the first time I sell a trust to someone, the very first thing they say is, Scott, how do I get the stuff out of the trust? I love that the trust can hold everything and make all this money and never pay any tax, because it's going to allocate everything to the corpus. Every time the money comes in, it allocates the corpus. It's declared extraordinary, just like the tax code says. It's a beautiful thing. But how do I get money out of the trust? That's what everybody asks. Well, what you have to understand is you never take it out of the trust, right? Okay, your home is always in the trust. Your cars are always in the trust. Your money is always in the trust. If you want to sell it, then sell it. But watch this. The money goes right back in the trust. And then what do? You take it and you buy another car or another house or a rental property or whatever, right? You're not taking the money out of the trust. You're leaving it there, and you're turning over assets is what you're doing. So I got to get money out of the trust. People think I want to buy Bitcoin or I want to buy a new car. Well, let the trust own the Bitcoin. Let the trust hold the new car, the Bitcoin, the new house, the rental property. Everything you want, you keep it in the trust. Okay. Now, let's go back to the 7 things that matter. Okay, because you have to understand these 7 things. The minute you understand these 7 things, the light bulb will click, and you will end up buying a trust. And if you don't buy a trust, then I'm going to run from you, because I don't want what's on you to jump off you and jump on me, because I want the 5 living benefits. And once you understand this, you're going to see the value of this, and hopefully you'll take advantage of it. Now watch this. Ownership. Okay. John Rockefeller said, own nothing. Nothing means nothing. So that means you cannot have anything over here. Okay. So own nothing. So ownership is the first problem that you have. Okay. When you're the owner, look what happens when you're the owner. You have massive taxes and you have massive lawsuits, because it happens. Remember, if you're the owner, they're going to come after you. You get in a car wreck. Okay. They not only sue the driver, they sue the owner of the car. Okay. And that's how it works in business too. Okay. I had a customer in California. The person that works for him ran over someone and killed him. Well, guess what? They sued his business, and he lost his business because they had the right to go after the owner. Okay. That's what I'm trying to explain to you. And remember, John Rockefeller says own nothing. Why do you think he says own nothing? It's because you pay the price for being the owner. And if you don't pay the price, you will. Watch this. So not only do you have high taxes, you have to pay for lawsuits. Even when you're innocent, you have to pay for the lawsuit. And by the way, you have to prove your innocence. Okay. So you're going to pay a lot of money just to prove you're innocent. Because why? Because you're the owner. Okay. The ownership comes with its advantages and disadvantages. So look right here. I just showed you 3 massive disadvantages by being the owner. You're going to have massive liability. You're going to have massive taxes. You're going to have massive lawsuits. If you haven't, you will. There are 3 advantages to being an owner. Okay. And I'm going to show you what they are. But I'm going to show you something better. Look right here. Management, control, and access. If you're the owner, you do get management, control, and access. But watch this. If you take these assets that you have in here, okay, I'm going to change the color. I'm going to use purple. If I take the assets that you have in here and I sell them into the Spendthrift Trust, okay, we put our house, our car, our boat, our gold, our guns, our jewelry, our money. You take everything you own, you put it in the Spendthrift Trust. You just got rid, okay, think about this. You just got rid of the liability, the taxes, and the lawsuits. Why? You don't own anything anymore, okay? But watch this. In the trust, you still have management, okay? You still get to manage the asset. You still have complete control, okay? By the way, over here, this was limited control. So in the personal estate, your control was limited. In the trust estate, your control was complete control. No, remember, no one can issue a turnover order and take it from you. So not only can you sell it, that's what control means, being able to buy it or sell it, but no one can take it from you. So management, you get to manage the asset. Control, you get to buy or sell the asset. That means get rid of it, divest yourself of it. But you also have access to it. Okay, so we'll watch this. Why do I need to be the owner of the house if I can put the house in the trust and still live in the house? Okay, remember, I don't live in a house, I live in a room. Okay, I don't live in the house, I live in our room, I sleep in my room. So what do? We have a caretaker lease. Okay, we have a caretaker lease because of in the trust, that trust owns my house. I don't own the house. The trust owns the house, but I live in the house. No, I live in the room. I rent the room in my house. Okay, I don't rent the house. I rent the room in the house. Why? Because I have the right to be in all the rooms. Why? Because I'm the trustee. Remember, I'm the trustee in the trust. I'm the trustee in the trust. I have the right to be in any. I have access. Remember the three things you take with you when you sell your assets in the trust. You're going to take the three positive things, okay, right here. You're going to take the three positive things and you're going to leave the three negative things, okay? We're going to take the management, the control, and the access. We're going to leave the liabilities, the taxes, and the lawsuits. We're leaving that over there. We're only taking what we need, what we want. I'm going to live for maybe 30 more years on this planet, 40 more years at the most. I don't need to own it. I just want to have management, control, and access. And guess what? When I die, my beneficiaries now become the trustee and they get management, control, and access. That's all they need. They don't need ownership. Okay. Now, why did I tell all this to you? Okay. Because I want you to understand what he was talking about. He's talking about owning nothing. Why? Because if I can tell you own nothing, in fact, everyone on this call has probably already heard own nothing, control everything. The problem is you didn't understand what it really means. And I'm going to try to show that to you. Okay. Owning nothing means nothing. So don't ask the question, how can I get stuff out? You don't ever need anything out of the trust. Okay. You don't need anything out of the trust. The trust can pay for the light bill, the water bill, the gas bill, the electric bill, the mortgage and the taxes and the insurance and the bug guy and the pool guy and it can pay for everything it owns. Okay, let's go back to the whiteboard. Okay, now let's draw this out again for a minute. This is you over here. Let's go back to the drawing. You own a house. You own a car. You have a bunch of money. Okay, the only reason that you pay the rent, the mortgage, the only reason you pay the mortgage or the light bill or the water bill or the gas bill or the electric bill or the mortgage and the taxes, insurance, the only reason you pay all of these things, okay, out of this bank account that you own is because of this one problem. What did he say? Don't be the owner of it. You're the owner of it. If you're the owner, you have to pay. That's the way it works. The owner always pays, okay? So there's a saying that says you get what you pay for and you always pay for what you get, okay? So you get what you pay for, but by God, you're going to pay for what you get. If you're the owner, you're going to pay the light bill and the water bill and the gas bill. And you're going to pay all this stuff. Why? Because you decided to be the owner. And you're going to pay for the liabilities of that house, that tree that falls on your neighbors. You're going to pay for that. You're going to be at fault because you're the owner. You're going to pay for all the taxes. Why? Well, because you brought the money into your personal estate. I can show you how to not take the money into your personal estate and you won't have this tax problem. Okay, so I can show you that. Now, so what I want you to see is how this works. So here's you, okay, and here's your house. Here's your money. Here's your car. What do? Step number one, what do? We sell everything to a trust. Notice, we do not give it to the trust. Okay, we do not grant it to the trust. What is giving? Giving is granting, granting is giving, giving is granting, granting is giving. We don't give or grant anything to the trust. And first of all, you have to understand, this is where all the attorneys mess up. This is where they mess up. They mess up because the minute the customer calls and says, give me a trust, what do? They set up a grantor trust. What does that mean? That means the person who called, okay, the client, the attorney makes the person the grantor. That's where they messed up, because and then what do? They make the grantor give or grant the asset over to the trust. Okay. Now you just put your customer into the wrong trust, the wrong tax code, the wrong bucket, the wrong. Okay. Okay. You don't want to be the grantor. Why? Well, on the tax website, the IRS website, there is a page that's called the abusive trust tax schemes, abusive trust schemes. Okay. The abusive trust schemes are always, look on there, they're always grantor trusts and they're always foreign trusts. Okay. They're always grantor and they're always foreign. So you don't want a grantor trust. Okay. Another reason you don't want a grantor trust. First of all, let me finish the idea I was trying to explain. You want the trust to own the house or hold the house. You want the trust to hold the car and all the money and everything. Remember, own nothing. Why do we want to own nothing? Because we want the three things that matter, and we don't want the three things that don't matter. Okay. I don't want the liabilities or taxes or losses. I don't want that. You can have it. I don't want it. Okay. I want management, access, and control. And that's it. That's all I want. I want management, I want access and control. Okay. That's all I care about. Now, going back to the attorney, let me explain that. There's a grantor, a trustee, and a beneficiary. Okay. If you, by the way, the only trusts that have any benefits at all, tax benefits or asset protection, are irrevocable trusts. Okay, only irrevocable trusts have tax benefits and asset protection. Revocable trusts have zero asset protection and zero tax benefits. But the minute you call the attorney, what did he do? He made you the grantor. Now, in an irrevocable trust, the IRS has a little trick they call the control test. Okay, now, the control test says that if it's irrevocable, remember, irrevocable, you have all the tax benefits and asset protection. What we call those living benefits, by the way. Okay. And I showed you the PowerPoint. I said these are the 5 living benefits, right? If you want those benefits, number one, you got to have an irrevocable trust. Number 2, you got to pass the control test. Okay. The control test means you only get one position. Okay. Don't get one position. You can't have 2. You can't be the grantor and the trustee at the same time. Okay, you can't do that. Why? Because you fail the control test. The control test says you only get one position. Well, you just called the attorney and the attorney screwed up because what did he do? He made you the grantor. Now you're screwed. Now you got to hire the bank to be the trustee. And you go down the road and you see ABC Bank and Trust. What are you seeing? You're seeing banks that are trustees for people, charging them 2% a year on all their assets, making a killing on the trust, all because your attorney made you the grantor. Okay, you don't need to be the grantor. Let someone else grant the first asset in the trust, the $50 or whatever the first asset is. Let someone else be the grantor. But let you be the trustee. But remember, you can't grant. Remember, there's a trick. You can't grant the assets in the trust. You can't do it. Why? Because now you have a grantor trust and you're the trustee. So you what? You fail the control test. You cannot have 2 positions. You only get one. So if you're going to be the trustee, look right here. You're the trustee. Your assets have to go into the trust through a contract. Have to go in through a contract. They cannot be gifted or granted because now you have a grantor trust. You can't have 2 positions. You'll fail the control test. So why do we sell everything to the trust? Why does everything have to have a bill of sale, notarized bill of sale? It's because you must at all times pass the control test. You cannot be the beneficiary and the trustee at the same time. You cannot be the trustee and the grantor at the same time. And you cannot be the grantor and the beneficiary at the same time. You can only have one position, and that position is the trustee. Now, your kids can be the beneficiaries all day long. Your preacher at your church can be the grantor all day long. Can't be you, though, or anyone in your family. That's how it works. Okay, I want you to understand how this works. Now, I don't want to spend too much time on it, but I want you to understand the basics of how the trust code works. Again, Own nothing, control everything. I did my best to explain to you what Rockefeller meant by that. Okay, you want benefits? You want 5 living benefits? You better not own the asset. Okay, you need to put it in the trust. It needs to go in through a contract. Why? Because you're the trustee. How can you control it if you're not the trustee? Okay, the bank controls it. How many times have you heard horror stories where the family never got the assets because some person that they made a trustee didn't give them the assets? Happens all day long, every day, and it's seeming to get worse. Okay, so when John Rockefeller died, his grandson, guess what? His grandson was a beneficiary. What happened? His grandson Nelson took over. Now his grandson was a successor trustee. So even his grandson said the secret is owning nothing but controlling everything. Okay, that's the secret. You can't own it. You got to get rid of your ownership. You don't need ownership. Ownership is an illusion. If you die and you can't take it with you anyway, you didn't own it. You only had management control, maybe, and access. You didn't own anything if you can't take it with you. Just so you know, I'm a Christian, and the Bible says that earth is the Lord's and the fullness thereof, the world and all that dwells in it. So you're not the owner. The Bible says God owns it all anyway. So don't try to be the owner if you're not the owner. So that's what I like to tell people. All right. Now, Lucy Parsons said, never be deceived that the rich will permit you. The rich will permit you. Never be deceived that the rich will permit you to vote away their wealth. They will not permit you to vote away their wealth. They're not going to let politicians come in and change anything, especially Article 1. They're never going to change Article 1. They will not let you change the 600s in the tax codes. They probably all use the 600s, just so you know. All right. The number one reason people come to us is probably for capital gains. Okay. Because if I put something in the trust, I can turn right around and sell it the very next minute, create this massive capital gain. Okay. And there's no tax to the trust because the tax code says, it says gains from the sale or exchange of a capital asset. What's a capital asset? Anything is capital. A rental property, that's a capital asset. The home I live in is capital. It says gains from the sale or exchange of capital assets shall be excluded. Right there, it's excluded. To the extent that the gains are allocated to corpus and you don't pay credit or require distribution to your beneficiary. That's what I was explaining a minute ago. Okay, so that's the number one reason people buy the trust, in my opinion. They want to be able to flip properties and flip all their assets and sell things without creating taxes. Okay, it's real important. All right. And so I have a lot other slides to go through. Let me see if I can get through some of these. Hold on a second. Key features of our trust. There are taxable distributions and there are expenses. So this is important to understand. Let's say you want to buy a car for your kid. Okay, if you give the kid the money for the car or give the car to the kid, you just created a taxable distribution in your trust. You don't want to do that. You want to let the trust buy the car, let the trust buy the house, let the trust buy everything that the kid needs. Okay, that's the way you do it. So this is the code, IRS code section 643. There shall be excluded those items of gross income. Okay, and that's, by the way, that is why there's no capital gains, because it says the gain is excluded. Okay, and so let me go here. I'm going to go through very quickly the 5 provisions. Irrevocability of the trust. Okay, the irrevocability of the trust is the first provision. The second provision is the non-grantor of the trust. Okay, we don't want it to be a grantor trust. Remember, we want it to be a non-grantor trust. The third is the discretionary provision. Most important one next to the spendthrift provision, I believe. You got to have discretion. The trust has to allow discretion too. What does that mean? That means you have the right to either distribute from the trust or not distribute. You have the discretion to do that. And then the complex provision is important too. You got to have the right to allocate to the corpus of the trust. Okay, so ours is a dual track, gives you both rights. You can distribute if you want, or you can allocate to corpus. We have both. And the last one is the spendthrift provision. This is the one that protects everything. This is the one that keeps the lawsuits from coming. Okay, Because I cannot knock on your door and say, Mr. Smith, I want you to please give me Mr. Jones' car. Mr. Smith can't give me Mr. Jones' car because Mr. Smith doesn't own Mr. Jones' car. So in the same way, they can't come and take money from your trust and give it to someone else because the trust doesn't own it itself. The trust has a spendthrift provision, which means it only holds title, not the equity. So it does, the equity is where the ownership is, not title. Title does not ever mean that's the owner, okay? Title does not tell you who the owner is. Equity tells you who the owner is, and equity is by contract always, okay? So you have a bill of sale, you sell the house to the trust, but you didn't change title. 10 years later, you get a lawsuit, you go to court, and you go to the court and you say, Judge, I'm sorry, I forgot to file the deed. Here's the deed and the bill of sale, okay? The judge has no choice but to dismiss the lawsuit because you can't take from the person didn't own. The house may have been in that person's name, doesn't mean they own it. Okay, there's no law in America that requires you to file a deed. He can file the deed 10 years later if he wants. Okay, he's not the owner. He sold it to the trust, so they can't sue him to take the house. Okay, he's not the owner. They have to sue the trust. The problem is they can't sue the trust now because the trust is a spendthrift trust. It only holds beneficial interest in the asset, doesn't or title. It doesn't own beneficial interest. It only owns title. It only has title through the contract. Well, but I don't understand. I look it up on the county and I see your name. I don't see the trust. That's right, but I'm not the owner. You can't sue me. Okay, so I'm going to sue the trust. Well, you can't sue the trust either. Why? Because the trust doesn't own it either. It only holds title. You can't sue the trust. The trust holds it for the benefit of the beneficiaries. Okay, the trust holds title, but not equity. It doesn't have the ownership. Why? Because it's just technically held and reserved for the beneficiaries. All assets in a trust are held for the benefit of the beneficiaries. And so that's how the spendthrift trust protects you from lawsuits. All right, so what are the key legalities of our trust? These are the 7 things that matter. At the end of the day, 7 things that matter that make our trust compliant to Scott on Trust, the Restatement of Trust, Internal Revenue Code, UPIA, Statute of Frauds, Rule Against Perpetuities, Uniform Trust Code. These are the 7 things that matter. Here's some key features of the trust. It's easy to set up, can be maintained by you, involves minimal paperwork. It actually, your life is so much more simple with the trust. You don't have to set up an LLC, a large lawsuit coming. You don't have to report to the state every year. Do this, you didn't send in the report. I just got a letter the other day. I got the letter from the state. I didn't send in my report. Now they're gonna, forfeit my LLC or something. You don't get those letters, okay? If you have a trust, trusts are not statutory. These trusts are non-statutory. You don't call the state, you don't report to the state, you never tell the state. The state has no business knowing about your trust. Okay, these trusts are non-statutory entities. They're not LLCs, they're not C Corps, they're not statutory in nature. So you don't have to report to any state. You don't even file a state tax return. Why? Because the Elliott versus Freeman, a Supreme Court ruling, says you don't have to. You're not subject to state or legislature. Okay, you're not subject to legislative control. They can't make you file a state tax return with this trust because you're not subject to the state tax. What's funny is if the IRS code says it's not income, how can the state call it income if the IRS code says it's not income? They can't. All right, we have a lot of case law behind everything we do. Remember 3 things: case law, contract law, and tax code. We have a lot of case law behind things that we do. I'm going to show just a few more slides here, and then we're going to go to Q&A. I don't want to talk too long. So I am recording the call, so you can go back and look at the slides if you want. And we're going to start with Q&A. So just keep in mind everyone is muted. So if you do have a question, please unmute yourself, and then you can ask the question. And so here's the last slide I want to show you. The Supreme Court holds that the trust relationship comes under the realm of equity. Remember, equity means ownership based on common law. It's not subject to legislative restrictions, as are corporations and other organizations created by legislative authority. LLCs are created by legislative authority. C corps, S corps, those are created by legislative authority. Okay, our trust is not subject to legislative authority. Why? Elliott versus Freeman. You can go read this Supreme Court ruling right there. It's not subject to legislative control. A spendthrift trust organization is not subject to legislative control, which is a beautiful thing. Okay, last thing I'm going to say before we do Q&A is this. If you have a C Corp, S Corp or LLC or association, all of those entities fall under what are called associations and corporations right here. What is designated as a trust or partnership may be classified as a corporation if, or association only if it possesses the corporate attribute, centralized management. Our trust has no CEO, has no president, has no secretary, doesn't have centralized management like that. It does not have continuity of existence. Why? When you set up a trust, it has an end date. Okay, it's called the law of perpetuity. Our trust has an end date, means it doesn't go forever. You set up a LLC or corporation, it technically goes forever. It doesn't have an end date. Our trust does not have continuity of existence. Our trust does not have free transferability of interest. Remember, the beneficiaries can't transfer their interest to anyone. Okay, it does not have free transferability of interest. And lastly, it does not have limited liability. All right, so I'm going to just click on a few of these slides so you can look at them later. And I'm going to go straight to Q&A. Anyone else have a question, or anyone have a question that I can answer?
Hey, if it was perpetual, then how would that be a negative? How does that impact it negatively?
Well, that's called an attribute. So if you did not have an end date to your trust, then the IRS could technically put you in the category in the tax code for corporations or associations. Okay, so that's why you need to have an end date when you write your trust document.
I was just with some people over yesterday, and they're like, "Oh, it has to be a perpetual trust," and like their attorney, they were talking about like it had. So I'm like, okay, so yeah, they don't even want that.
No, I don't want my trust falling into the category of associations and corporations. So it's called. So that's why my trust has an end date to it. Right there, it's free. Let's see, continuity of existence. So I do not want continuity of existence. I don't want it to go forever. I want it to have an end date. But watch this. In 21 years, it doesn't mean my trust is over with. I simply open my book, go to the renewal page. By the way, the trust is a contract. You can renew a contract, right? The TV people renew my contract without my permission sometimes, okay? Trust or contracts can be renewed, okay? So my contract is simply renewed by me opening my book and signing one piece of paper. So, all right. Anyone else have a question?
What's the typical period of time you set up a trust for, just out of curiosity?
It's usually 21 years because all states have that law of perpetuity. Most all states. And that's the minimum, by the way. Some states are 100 years, but the minimum with all states are 21. So we have a 21-year renewable option in our trust.
And what is the construct if your main trust has like two sub trusts? Let's say myself and my wife want to have our own sub trusts.
Can you rephrase your question, please?
Okay. Well, if we have an asset that goes into the trust that we each own 50% of,
okay,
and we're separated, can we set up sub trusts for ourselves within that trust, or does it have to all stay in the main trust?
So what you do is when you put it in the trust, what you do is you each sell your position to the trust. So when you sell the asset to the trust, we don't want to split the baby in half, right? But what you want to do is you want to sell your position, which means each of you get your own demand note for the 50% equity. So you haven't lost any value at all. Say it's 100 grand, right? Your demand note's 50,000, her demand note's 50,000. You still own your share of the equity, but it's through a promissory note. We don't cut the baby in half.
Can a court garnish a demand note?
No, no, it's not subject to turnover. Demand notes are not subject to turnover order. Absolutely not.
Thank you.
You're welcome. All right. Well, thanks for coming, everyone. I did record the call. And if you would like a copy, you'll need to reach out to someone so we can get you a copy. So please reach out to the person who invited you to the call, though, and go through them. They deserve to work with you instead of you coming to Nexxess directly if they did invite you to the call. So, all right. You guys have a great day, and we'll see you next time.
Thanks a lot, Scott.
See you later.
All right.
Have fun. Bye.
See you, everybody.